Hey, what's going on, everyone? It's Camille Prosperity out of Savannah, Georgia. My apologies for being a little bit late, but it's a Friday night and there's a lot going on. For those of you who do not know me, I help you out with a lot of different things. However, I do not offer legal advice. I'm not a lawyer, paralegal, none of them things. I'm just a country girl sitting on the internet in Savannah, Georgia, reading and making people laugh while educating, okay? And tonight, what we are going to do, first of all, as you come in, regardless of whether you are watching live or a replay viewer, go ahead and before you forget, like this video because it's really going to help in an algorithm. Subscribe to my channel if you haven't done so previously, and share this video out, especially if you know anyone who is going through a divorce. But honestly, this video is going to have a lot of you really thinking about talking to your loved ones and even yourself, as it relates to just making provisions for your family in the event that you transition unexpectedly. Okay, so um, yeah, yeah. Now, first things first, tell me where you're watching from, not only the city and the state, but you know what we want to know over here. Drop your district, say your circuit. Drop your district, say your circuit. um, we went over this last night. There are 11 districts or circuits of the courts. And so, depending on what state you live in, that will determine your district that you drop or your circuit that you say. So, drop your district, say your circuit, along with your city and state. All right? Oakley dokley. Now, I also want to know how many of you saw last night's live where we talked about how to find court cases in your district or in your circuit. People are still commenting on that video. I'm getting really good feedback about it. A lot of you, some of you knew about Hustia, but you had not actually used it. People engaged with the video saying, I'm signing up now. So you should have gotten some court cases to your inbox as early as today because they are really quick with it. Now, along those same lines, I got a court case to my inbox today that I thought was because I signed up for a whole lot of topics from Hustia. Hold on one second. And I actually got a court case today that I thought was very interesting. Muy interesante. And so I wanted to go over it with you guys, right? Okay, I had to make sure my audio was working well. So let me show you what we are going to talk about today. And as you come, say hello to your girl. You know I like interaction, participation. Don't make me feel lonely. All right. So listen, this is a court case in the trust and estates. I subscribe to trust and estates because this is a very hot topic right now, as it should be. It is a very interesting topic, guys. So even if you came to my channel about credit, I strongly suggest you subscribe to the trust and estates Hustia email like case listings. If you don't know how to do that, then go to my previous video, literally the night before. Let me show you what it looks like so you'll at least know the thumbnail. I know some of y'all like, why don't you just have the thumbnail pop up? I don't do editing and all that other stuff. Okay. We're on a real lean budget over here. So you're gonna have to do the legwork. Okay. So let me show you the video I am talking about. I'm talking about this video right here called Reading Court Cases from Judges in Your District Circuit. Okay. This is the video that you will want.
$18,699,675.97.
Okay. This is the video that you'll want to watch to show you how to subscribe to court cases. We had a lot of engagement last night, a lot of interaction. So shout out to everybody who was on live to participate with me in real time. If you missed it, it's a-okay. Go back and watch it because it was really good. And it will tell you exactly how to get, and if you're like, oh, this video is long, first of all, stop it. but I did put the timestamps here so that you can jump to just to where you need to be. But I strongly advise you to watch the entire video, okay? Alrighty. So today's court case, guys, is Schlegel versus Barney and Graham LLC, okay? Let me see here. All right, so let's read the summary really quick. All right. And this is the opinion date. This is the beginning of October. This is very recent. This was out there in Wyoming. Okay, so not my district. Yes, I get court cases from other circuits and districts as well. But you know what? Actually, let's skip over the summary because I don't want to repeat stuff. Let's go straight to the opinion. Shall we? Yes, I think we shall. So let's go straight to the opinion and read directly from the court complaint. Okay, hold on a second. Here we go. I think I really have overloaded my poor little laptop. When did I buy this laptop? In 2020? Yeah, I've done a lot of damage in 3 years. Uploading content to it and things of that nature. Right now, it's a little bit frozen. So hold on. All right, while I'm waiting for this, I guess I will read the summary. Dagnammit. Okay, it says the Supreme Court affirmed the decision of the District Court granting summary judgment. And as I'm writing this, as I'm reading this stuff, guys, I want you to write down any words or phrases that you do not know. For example, do you know what affirm means? Don't be embarrassed if you don't. That's perfectly fine. This is a place where you come to learn, okay? Do you know what summary judgment is? If not, write it down and we'll go through that. Let me know. All right, we can look it up together and figure it out together. Again, and if there's any lawyers or legal people, these videos tend to attract critics who are like, you're doing that wrong. You said it wrong. You did that wrong. Great. I hope for everybody that has something negative to say about what I'm doing, I can click on your name and go to your channel, and you're putting yourself out there and doing it even better than me. If not, shuddy. Yep, I said it. Shuddy. Hold on one second, y'all. Let me see something. Okay, so at least my audio is still going, even though my screen appears to be frozen. I'm trying to shut down stuff, but I don't have that much stuff open. This is so weird. Okay, hold on. Yeah, my poor little laptop. I only have 3 tabs open and it's acting like I have 30. This is ticking me off. Anywho. Okay, I think I'm back. I closed Discord and something else. And I think I am good now. Let me see here. And I'm going to close things as I go. Here we go. Please. All right, and then share this tab instead. Perfect. We are only going to open up what we need. So we are going to read from the actual opinion, okay? But I want to bring your attention to something else that I neglected to tell you guys last night. There is an annotation here that you can click on and you can read some other stuff. It's not much on this one, but yeah, it's always good to read as much as possible, okay? All right, so let's get into this opinion. We're going to be looking at the actual, what do you call it, PDF? Oh, wait. There we go. We're going to look at the actual PDF of the complaint. Can I make it bigger? I'm going to say home. Can I? Nah. Okay, let me see how that looks on my other screen, how it looks to y'all. It's okay, I guess. I guess it'll work. Okay, let's just get into it. We already know that we talked about this last night about like the formatting of a case. Here we have the plaintiff and the defendants. Okay. Um, this is an appeal. It tells you the county, tells you the judge. Um, you can read all that stuff for yourself. This is pretty small for my eyes. Let me see here. Will this work? I don't think I can get any bigger. That's interesting. Let me see something, y'all. Hold on. Um, let's do. I'm surprised I can't. It looks like I can do it here. And then do it there. Nope, it still doesn't. Okay, hold on one second, y'all. Just give me 1 second. Stop sharing for a moment. Oh, you guys are not interacting with me tonight? What's going on? I think everybody's partying. See, y'all ain't about this life. No, I'm just playing. I can't. You can't say that to the people who are actually here and showed up. Okay, I'm going to try something to see if we can get this document much bigger. I thought I was ready, but I wasn't. All right, let's see here. If I do that, because I know most of you are watching on your phones, and I'm looking at it on my phone, and this is just, yeah, that's not going to work for us. So this should help out greatly. Okay, let's see if this works for you all. Aquario Soul said, "Is this for those going through a divorce?" This is not divorce advice. However, this is a case regarding two people that went through a divorce, and one person died during the proceedings. So it was just an interest. I don't recognize your username, so I guess you're new to this channel. So no, this is not going to tell you like how to get through a divorce, but it is something that anybody going through a divorce should be mindful of. Okay, I hope that helps you out. And if you're going through a divorce, then I'm sorry for the dissolution of your marriage, but happy for you finalizing it and moving on. Been there myself. Nobody likes to do it, but there are brighter days. Okay. All right. Let's see if sharing the screen now helps. So this is going to be kind of like a study hall session, you guys. All right. This okay. Oh, you responded. You said got it. Came on a while ago. Sis is going through it. Okay, I'm so sorry to hear that. I'm so sorry to hear that. But things will get better. It is a tough and arduous process. Um, it can be depending on the parties. But if you were not in a good place at the time, then yeah, it can be pretty rough. But I will say this. Get it over as quickly as possible, because really the only people who win a divorce really are the lawyers. All right, so let's get into it. Can you guys see this now? Let me check. Is this better for you all? Because I started reading this and I said, oh, this is juicy. I need to share this with the fam. Okay, yes, this is much better. I see it on my screen. All right, so we're going to keep this together. So the husband, Michael, and the wife, Charlene, were in the process of divorcing when Michael died of a heart attack without a will. Okay? Under the intestacy statute, Charlene inherited portions of Michael's estate that she would not have had the divorce been finalized before he died, right? Now, Taryn is Michael's only living child, and he filed a legal malpractice suit against his father's attorney, who is Shelby, and her law firm, which is Barney and Graham, right? For failing to timely resolve Michael's divorce, his dad's divorce. The district court granted Miss Hughes and Barney, the law firm, motion for summary judgment. It found no evidence was presented that Taryn, the son, was an intended beneficiary of his father's attorney's services, and thus no duty was owed to Taryn. We affirm, which basically means we agree. Okay? So, based on what you just saw, do you think Taryn, the son, won his case or lost his case? Drop down below in the comments. Did he win or did he lose? What do you think? And in the meantime, what I am going to do, we're going to do a little bit of word search because it is very important when you're reading this stuff. Summary judgment is something that you're going to hear a lot of if and when you ever have to go to court. Well, we'll just say when you go to court. Even if it's pertaining to credit cards, a lot of times they will request that the judge grant summary judgment. And you need to know what that means, okay? So, based on what I just read, do you think the son won or lost his case? Anybody comment? Right. Aquaria Soul said he lost. Exactly. Because we saw it right there where it said it found no evidence was presented that Taryn was a beneficiary, and so therefore no duty was owed to Taryn, which that was his claim, that the attorneys owed him to resolve the situation quickly. And the appellate court, which is who he took this to, says we affirm, which means we agree. They agree with the decision of the other judge that the lawyers owe him nothing, basically. Okay? So when we look at what summary judgment is, guys, it is a decision based on statements and evidence without going to trial. It's a final decision by a judge and is designed to resolve a lawsuit before going to court. Why? Because the courts are clogged up, and oftentimes you can really see beforehand whether or not somebody is about something or not, whether there is a dispute that needs to be resolved using a third party mediator, arbitrator, such as a judge. It's just like you can kind of sort of see somebody coming towards you, somebody who wants to flirt with you, and you like, nah, this ain't it. Before they even open a word, they don't have a chance. Okay, summary judgment is the same thing. The judge can look at everything that is presented without having to hear people actually argue their case and say, no, there's no way this person can possibly win. Does that make sense? And did you guys know what summary judgment was? Because if you didn't, now you know. Yo, slick blow. It's driving me. All right. So let's go back to the complaint and let's read the issue. So the issue is, did the district court err, means make an error, when it found no evidence was presented indicating Taryn, the son, who is a non-client of the attorneys, keep that in mind, okay, he didn't pay them. Did they make a mistake when they found that he didn't have any evidence indicating he was the intended beneficiary of legal services provided by his father's law firm? So you're always going to have a major question in court, and then you have to look at what are the facts, right? Now, this is where it gets juicy, y'all. And I hate to say that because these are real people. Let's understand this, okay? These are real people. Aquario Soul said, thank you, gotta go. Okay, no problem at all. I'm happy you stopped through. Thanks for your participation and best wishes to you. So these are real life people, y'all. So I'm not trying to make it sound like they're not, or be disrespectful in any way, shape, or form. But this is how people be living. Okay. Now listen to this. Michael and Charlene married 3 times and divorced 2 times between 1999 and 2017. So what is that? In an 8-year span, they married 3. Dang, what is that? Marrying like every 2. Oh, that is. Yeah, it is. You're right. It's not. What is it? You said how many years? 18 years. Thank you. You know I'm not good at math. So in 18 years, okay, that's a little bit better. In 18 years, they married 3 times. So that means every what? Every how many years they were getting married? 3 times in 18 years, 6 years? Every 6 years they get married? All right. So they separated for the third and final time, June of 2018, after having remarried a year earlier. Wow. Now, Michael had 2 sons before her, Taryn and Kaylin. But unfortunately, Kaylin transitioned before his father died, before his father did. Okay. But Kaylin had 2 children. They were still minors at the time that their grandfather passed on. Okay. So Taryn doesn't like his stepmother that much. The one remaining child of Michael, Taryn, doesn't he not feeling Charlene, the stepmother. He told his dad on multiple times to leave her. Now, the dad met with his attorney for divorce representation in the spring of 2019. Okay? Now, before this meeting, he had a stroke, and so he couldn't really talk that well. Therefore, his sister, Punky Bradley, I like that name, his sister went to the first meeting with her brother and his attorney to help because he couldn't talk that well due to the stroke, right? Now, the attorney in this meeting learned that he had one living son, and Miss Bradley, as well as Miss Bradley is the sister, Punky, as well as other members of Michael's family, they didn't like the wife. They didn't like Charlene. And they believed she had absconded with Michael's money. Now, do we know what the word absconded means? I'm sure, even if you know, there's going to be somebody watching this who does not know. So let's look up the word absconded, class, right? So here we have on the handy dandy Google, absconded means leave hurriedly and secretly, typically to avoid detection or arrest for an unlawful action such as theft. Okay? So other synonyms for it are run away, escape, clear out, flee, take flight. So homegirl was like deuces with the money, right? Nobody liked Charlene. So now we go to Michael hired Miss Hughes to represent him for his third divorce from her. Now, the attorney filed a complaint for divorce on Michael's behalf April 2nd of 2019. When did he start all this? He started in the spring of 2019. And guys, let me tell you guys something. In case you've never been involved in court, they do not move fast, okay? Just because you don't love the person anymore does not mean this thing is going to be over and done with in a week or two. My divorce took, I think about a year. Yeah, a little over a year. And I know people who have taken longer than that. And I thought my divorce would take 3 months, but nope, it was a year. Longest year of my life, okay? Now, and this is pretty typical. And depending on when you file, keep in mind this is April 2nd, 2019 is when the divorce complaint filed. Now, we all know what happened in 2020. So let's read and see what happened with Michael and Charlene. So he filed the complaint. The complaint was actually filed April 2019. Charlene didn't answer. And so a default was entered against her. It's like she didn't show up. So silence is acquiescence. And therefore they proceeded with a hearing. So here you see a default hearing was scheduled to be held June 20th, 2019. So see, he filed the beginning of April. The default hearing wasn't until the end of the following month. Charlene appeared pro se. What does that mean? That means she represented herself. Okay? She didn't have a lawyer. Her husband had a lawyer. She did not have one. The district court continued the hearing to allow her to get a lawyer. But what did Charlene do? Now the default hearing is scheduled for, remember, we were at the end of June. Now it's the end of September. September 20th is when the default hearing was rescheduled for her to get a lawyer. Homie showed up without a lawyer again, y'all. Charlene just didn't care. So Miss Hughes, who is the attorney, told the district court Michael wanted this divorce done for the third time. He wanted it resolved. But the problem is they were disagreeing on personal property issues, specifically the cars. Now, I don't know how many cars there are, but they were beefing over these cars, y'all. The district court said if the attorney would send a proposed decree of divorce that divided all the property except the cars, that's what they were mainly fighting about, the court would enter a divorce decree. And the vehicles, the cars, could be addressed in a separate hearing if necessary. The district court further stated to the attorney, so get me the decree, get your client divorced. All right? Now, I'm not going to lie, just from my own personal experience, I would want everything one and done. Don't be having separate hearings for me, because sometimes that can mean separate filing fees, paying the attorney more. We need to come to an agreement ASAP Rocky on this stuff and get it over and done with. I'm telling y'all, if you're going through a divorce, don't be dragging stuff out, because whatever the value of that property is, you probably going to drain it paying your dang on lawyers and time and frustration and gray hairs fussing over this stuff. If you got a fool for an ex, sometimes your peace is worth it. All right, your peace is priceless. Anywho, following this hearing, the lawyer did not immediately provide a proposed divorce decree to the district court. This is important. Instead, the lawyer attempted to have Michael complete his initial disclosures so that all property could be distributed in the divorce decree. Now, see, that's not what the judge said to do. The judge said to have a separate hearing for the cars, and that's mainly what they were beefing over. All right? Now, Michael, who is the husband, did not return the initial disclosures to his lawyer, although he did inform her he was working on them. Gathering paperwork for a divorce is the worst. So the lawyer made a settlement offer to Charlene, the wife, but Charlene didn't answer. Y'all, Charlene don't care. Charlene just don't care. He filed for divorce. She didn't answer. They went to court. She didn't have a lawyer. Judge gave her another hearing to get a lawyer. She showed up again with no lawyer. The lawyer makes a settlement offer. She didn't answer. Charlene, like, screw all y'all. On January 15th, 2020. Now, remember, he started all this April 2019. So here we are 6 months, a little over 6 months later. And it says on January 15th, 2020, following the court's judicial assistant inquiring about the matter, Ms. Hughes, the attorney, requested a hearing to resolve the vehicle distribution. This hearing was scheduled for 3 months later, okay, March 26, 2020. Now, on February 23rd, right before the hearing, Michael, the husband, died of a heart attack with no known will. Now, they all knew he was sickly because of his stroke, but they didn't think he was going to transition. So this is where we really get to the meat and potatoes of this issue right here. Now, are y'all learning something from reading this and having me go through this court case with you? Isn't this interesting? So the day after Michael's death, Charlene, dang, she didn't waste no time. The day after Michael's death, Charlene filed a motion to dismiss the divorce complaint. The attorney provided a proposed divorce decree to the district court. Her firm, the law firm, argued the district court had granted a divorce at the September hearing and bifurcated the proceedings. Do you guys know what the word bifurcate means? This is something that you're going to see a lot in law, okay? So let's look it up, please. Handy dandy Google says that something that is bifurcated is divided into two branches, okay? So when you have a trial, that's where the judge was saying, hey, let's give the divorce decree and then do a separate hearing for the cars. So because the cars were the point of contention, that was what they could not agree on, seemingly. So the judge was trying to split the cars and have a separate hearing. That's why they used the term bifurcated. Does that make sense to you all? Does that help you out? Okay. So let's go back to the case. The court had granted a divorce and bifurcated the proceedings. Ultimately, the district court dismissed the divorce complaint with prejudice. Super important here. We talked about this last night. What does it mean when something is dismissed with prejudice? That means it's final. That means it's done, finito. Okay? Now, if it was dismissed without prejudice, that means you can bring that claim back around. But there's no bringing this claim back around because Michael's dead, right? So the district court dismissed the divorce with prejudice. What does that mean? That means they still married. Y'all, are y'all following that? Do y'all get that? Woo! Now let's look at some of these notations here, these footnotes. Remember Taryn is the son. Taryn believed that his dad intended for him to inherit the entire estate. He also believed a will existed, but he couldn't find it. Okay? Now, Taryn argued in the district court the statements made by the court in the September default hearing were an indication the court intended to grant a divorce. Okay? Wyoming recognizes bifurcated divorce proceedings, although granting bifurcation is a matter of judicial discretion. Everything is a matter of dang on judicial discretion. I done told y'all, just because one judge does something doesn't mean another judge will do it. Your judges are oftentimes they're people. They're not like people. They are people, and they function like your parents. What so-and-so mama got to do with me? I ain't their mama. Sounds like you need to be so-and-so's child then. That's kind of how you should think about it. You can bring up a prior court decision by another judge, but that does not necessarily mean that your judge is going to kowtow to what that other judge did. He still has their own mind. He or her still has his or her own mind. And if they decide that they have basis to make a decision different from that prior judge, they will. They'll do it right in your face. So here, this is a court. Remember, I told you we can look up court cases. I'm not going to do that tonight because I don't want this broadcast to be too long, but you can look up this court case and see the decision. However, they tell you right here, in the Kelly case, the plaintiff was in critical condition in the hospital and requesting an immediate divorce from the defendant, her husband, so he couldn't make healthcare decisions about her or inherit her share of the marital property. Oh, wouldn't that be a tizzy? Wouldn't that be a tizzy if you in the hospital and you're married to somebody who you can't stand and you think they might unalive you, might make a decision that could unalive you? So now you got to rush to get a divorce from a hospital bed? Woo! So it says, in affirming the district court's grant of an immediate divorce for that person, while reserving the issue of property division for a later date, they explained this. This was the explanation. Why Wyoming does not have a statutory provision expressly authorizing courts to grant a divorce in one proceeding and determine an equitable, that means like equal, fair, an equitable division. And let me tell y'all something, in divorce is never equitable. It's never fair unless the two of you agree to it on your own. But if you get that judge involved, oh, you can forget about it. Forget about it, right? So Wyoming does not have a statutory provision expressly authorizing courts to grant a divorce in one proceeding and determine an equitable division of the marital property in another proceeding. However, the trial of issues separately is acceptable, such as in criminal court cases where guilt, we'll have to go down here, and punishment are determined so separately. We've all seen that done. Or sometimes in personal injury cases where liability and damages are tried separately. Additionally, we can look this up, but this is some kind of like statute, I believe. Expressly contemplate the rendering of a judgment as a matter of law on some issues and a later trial on any remaining factual issues. Y'all, court and trials and all proceedings, they can get very, very complicated. But I tell you this, the more you can agree with your adversary, and Yusufel talks about this all the time. I believe he quotes Matthew 5:25. And let me see if I'm right, just from memory from watching his videos. Am I right? Let me see. Yep. This is a quote that he uses all of the time. Desde la Biblia, from the Bible, y'all. Agree with you. Settle matters quickly with your adversary who is taking you to court. Do it while you are still together on the way, or your adversary may hand you over to the judge, and the judge may hand you over to the officer, and you may be thrown into prison. Y'all, that is so true. When you are going, and that's why, like, all of these affidavits of truth and all of your evidence, remember, court is not the building. It's the paperwork that you shift back and forth before you get to the building. You have to make an honest attempt to resolve the matters, or at least, and definitely have proof and evidence that you have tried to resolve the matter beforehand. That is going to put you in a more favorable light when you go before the judge. But too many people that are, shotgun court case filers, oftentimes they find that a judge will grant summary judgment and throw their case out before it's even seen, because they see there is no case there. You want to exhaust all possibilities to reach a resolution, to show the judge, listen, I come here with clean hands, clean heart, did everything possible, and that's how you want it to be. So let me see here. Let's go back to where we were. Now, so they threw Terrence's case out. Now, this is where we get to the nitty-gritty of the why. Why did they throw the son's case out, right? So let me close these tabs too. Had the divorce been completed before his dad died, Terrence would have inherited 50% of the estate under the intestacy statute. What is intestacy? All right. Y'all know what that word means. We are really, see, this is the boring stuff. Everybody wants to talk about, here's how much you can get, and do you want some money? What's your remedy? But no, there are so many steps to get to that point, guys. You got to look up the definitions. You got to understand how court works. You got to understand what you have to prove in court. It's not just, this YouTuber told me that this statute said if they don't do what I say, because I'm the consumer and I got the power, and then here's the fine. Now give me my money. What do you mean my money? That's not how court works, y'all. Okay? There's a lot of boring stuff. And all those people that you see who are actually getting remedy, trust me, they understand exactly what I'm doing right here. Even though this is not about credit cards or, your rights as a consumer law stuff that I usually talk about, I felt like this was an interesting case that we definitely should address, because way too many things are going on right now with people's health and people meeting untimely demise. I really, really hope that watching this video encourages you to talk to your parents, especially if they don't like their spouse or anybody that you know, and get some things in writing and find out what is what, because all too often family members are left struggling to find some evidence of a person's intentions when none are there. And when you don't lay out how you want things to be, that's when somebody who don't even know you tells your family. And that's what you don't want. So intestacy is a state of dying without a will. If a person dies without a will, they are said to have died intestate. Have you ever heard this? The estate of a person who has died intestate goes through probate court, right? You can't just go up in the house and be like, give me the keys. It don't work like that. The state's intestacy rules will determine who will inherit the decedent's assets. The decedent's assets. And again, it's state rules. So what might happen in Georgia is not going to be exactly the same as what might happen in California. All right? Did y'all know that? Okay, so I thought I shared this tab. This is where I got it from, y'all. The handy dandy Googler. I thought I shared this tab, but my bad. It was still on the other thing. So yeah, if somebody dies intestate, it's without a will. And that means you can't say what that person wanted. Okay? And because you have no proof of it. So yeah, we need to be careful about that. It's a scary thing, y'all. So if the divorce had been completed, the son would have gotten 50%, right? And this is the statute, the Wyoming statute that says so. But because the divorce was not completed before he transitioned, Charlene, who was still his wife, it doesn't matter that they were going through divorce proceedings. It's not done until it's done, okay? So Charlene, his wife, inherited 50% of Michael's estate. Where did the remaining 50% go? Well, Taryn, who is the plaintiff in this case, who wanted 50%, he got 25%. And then remember, now his brother, Kalen, had already transitioned. He passed on before his father, but he had 2 kids. So Taryn got 25% as the son, and then his 2, I guess, nieces or nephews, they got 25% in equal shares. So Taryn got 25. The 2 kids got 25, and then she got, excuse me. I said the 2 kids got 25, but what I really meant was the 2 kids got half of 25. So they got half of the remaining 25% in equal shares. But the wife, who is still technically the wife, doesn't matter that he wanted her to be the ex-wife, she got the lion's share, the majority of the estate. So the son, Taryn, argued this difference resulted in Charlene receiving approximately $500,000. Wow. Had the divorce been finalized prior to Michael's death, she would have only been entitled to make a claim against the estate for a vehicle worth a few $1,000s. Do y'all see this? So homegirl was in the middle of divorce proceedings from somebody that she had married 3 times, divorced twice. This was going to be the 3rd divorce. They were arguing over some cars that were worth a few $1,000s when her then husband transitioned, passed on. Instead of her, let's say she won all the cars, it would have only been a few $1,000s. But instead, because he passed on, she got a half of an estate, a portion of his estate worth $500,000. Interesting. Isn't this interesting? So the son filed a complaint against the law firm. He was like, I'm not leaving here without something. What's the Denzel Washington thing? I'm leaving here with something. Taryn said, I'm leaving him with something. And 25% wasn't enough. So he filed a complaint against his father's law firm for legal malpractice. In his complaint, he said that the law firm's negligent delay in presenting a divorce decree to the district court after the September default hearing led to the diminishment of his inheritance. Now, the law firm filed a motion for summary judgment. Remember, we just talked about that, arguing they didn't owe Taryn nothing. He's not even a client. They're like, who is you? The district court granted the law firm's motion, meaning they agreed, and the district court concluded the following. In certain circumstances, an attorney owes a duty to a non-client, to someone that is not their client. The threshold inquiry is whether Taryn, the son, is an intended beneficiary of the attorney's services. The court cannot identify any facts on the record. Remember, we talked about this a few days ago, about last week, about are you ready for court? Remember, when you talk, you are not talking to the judge, you are talking to the record. So the court cannot identify any facts on the record indicating that Michael, his father, sought his divorce with the intention of enlarging his son's inheritance. This is key. This is key because Taryn is trying to say because of this equals that. Okay, Taryn is trying to say because the law firm was slow in filing the divorce decree, his inheritance was diminished. The court is saying, slow your roll there, not necessarily so. Just because, let's say the divorce had gone through, that doesn't mean that your father was going to alter the will and increase your share. He could have had a best friend, a neighbor, a golf buddy, a mistress that he was going to give that money to. You don't know. Therefore, Taryn, the son, lacks standing to pursue legal malpractice claims against his father's attorneys as a matter of law. This is important. Standing means, do you have a right, basically? Like, how did you get here? Are you supposed to be here? Right? So you'll often hear in law, they'll always say, do you have standing? And a lot of times people conflate this word with venue, with jurisdiction. No. Standing is your right to sue. Okay? Let me show y'all what the handy dandy Googler here says. What does standing mean in law? At its most basic meaning, standing is the right of a party to challenge the conduct of another party in court. Okay? It's not about the actual issues of the case. It's about the parties, the people, plaintiff and defendant, involved in the lawsuit and where they stand in relation towards each other's. Okay? Courts treat standing as an antecedent to a lawsuit. So basically what the court is saying is, although Taryn was his son, they don't know the relationship of the son of Taryn and Michael. They don't know, again, they don't know if Michael was going to amend the will and give Taryn a lion's share. Taryn bringing forth this lawsuit against Michael's attorneys is basically the equivalent of, like I said, a neighbor who lived next to Michael for 30 years saying, well, Michael told me across the fence one day when we were smoking, Michael told me one day when we were shooting pool, a buddy's night, that he was going to give me a portion of his estate. And then the neighbor filing this lawsuit against Michael's attorneys. There's no, what is your standing? You have no standing to sue this. You're not their client. And there's no indication, there's no proof of what you are saying. So you have no basis, you have no standing to bring forth this lawsuit. Okay? Very, very important. How does this translate to for some of you? A lot of times on this channel, we talk about credit, and you guys are being sued by third-party debt collectors. What you do not know is that they often don't have any standing to sue you. Now, it might appear that they do because they can produce maybe one or two statements with your name on it, and you're like, well, I did have that credit card, and they did say they bought it. However, if there is a purchase agreement, not just a bill of sale, but if there is a purchase agreement stating, hey, the original creditor says to the debt collector, I'll sell this debt to you for pennies on the dollar. There might be a disclaimer in there that also states, provided that you do not sue the consumer and bring us into a legal court battle, because we are not affirming anything about the validity of this debt. And that's usually how these transactions are done. They're very loose. They're very, a lot of times these companies don't have every single statement showing that the balance was correct on every single statement. So they might give them a handful of statements and be like, hey, here, you can buy this $10,000 debt for $500. And then the third-party debt collector wants to come after you for the full $10,000, knowing that even if they say, hey, we'll give you a deal, well, what about half off there, guy? What about $5,000 instead of $10,000? And here you are thinking you just saved $5,000, but how much profit did they just make? $4,500, right? So they're like, woohoo! But the whole time they really had no right to come after you, even though you owed the original creditor, not them. And they bought the debt with a disclaimer that they would not sue you. But you don't know that because you didn't see the purchase agreement. Again, now tonight, let me tell y'all something. Tonight's class is not for the newbie to my channel. This is for somebody who done been here a while. All right. You you got some war wounds with me on this channel, okay? You done seen a few videos. We went deep tonight, but really that's what standing is all about. All right. So when we go right here to Taryn, he still didn't back down without a fight. So Taryn appealed, y'all. He said, no, y'all got it wrong. And basically, as you saw in the summary earlier, they even on appeal, they were like, no, son, you got it wrong. We don't know what your daddy wanted. He didn't have a will. So isn't that something, y'all? The wife got half of his estate. Half of his estate was what? 500,000, $500,000. That means his entire estate was $1 million. That means this man was a millionaire without a will. Isn't that interesting? Isn't that interesting? So I'm not going to read the rest of this, but we went through what? We went through half of it, guys. We went through 5 out of 10 pages. What we did not review is what we did not go over is the standard of review and the discussion. So this is very, very interesting. The discussion, the standard of review, all of these different sections are going to give you a sneak peek into how the courts and judges think. And this is what you need to understand, because sometimes just because something is cut and dry to you doesn't mean it's going to be cut and dry to them at all. You got to remember, you are the one that is going through this thing, and you know all of the intricacies. You know everything. For however many years you've had this dispute with whoever it is you are taking to court, or whoever is taking you to court. But oftentimes what you know, there's no evidence of. What you know, you cannot show. So it doesn't even count. But even if you know it, you got to gather it. Gathering paperwork, going through the process of discovery, knowing what questions to ask the other side, answering their questions. Oh my gosh. It's a whole nother job. It's a whole nother job, y'all. And depending on how big the case is, it could really take a long time and be very, very thorough and in depth. Right? So in doing that, and this is why a lot of people say it's not worth it going to court. This is why a lot of people settle before court once they see the case has been filed, because they don't want to go through the hassle. This is why a lot of people also get lawyers, because they don't know how to submit all of that paperwork correctly. And a lot of times they do it wrong, and the other side gets a judgment just because you didn't know what the heck you were doing. So don't let anybody fool you. This stuff is not easy. It is worth it. But if you expose yourself to how the legal system works, then not if, but when you find yourself entangled in it, you'll be able to maneuver a little bit better. Again, I strongly advise you to go watch last night's video where we talked about how to sign up for these email notifications. And as they come to your inbox, just take a look at the summary and then decide if you want to actually go through and read the PDF full-fledged complaint, because I'm telling you, you will learn so much just reading what the issue was, what the decision was, and why. Especially if you are the type of person who goes the extra mile and you start looking at the annotations and the citations, and you reference the laws and the prior cases that they cited, man, you're going to be a bad mama jamma. So let me go back to StreamYard. I know this was a lot. I'm going to stop sharing. All right, we still got a few people on with us, but not nearly as many as we usually have. See, y'all don't like the hard work. Y'all don't like to put no elbow grease and stuff. This was serious business right here. I hope y'all enjoyed it though. Drop down and replay viewers, because my live viewers, they done left me hanging. My live viewers, they on the Beyonce mute challenge. Replay viewers, let me know. Did you enjoy this? Should I do more of these? Did this make you think any differently about talking to your loved ones who may be going through a divorce, or even if they have not divorced, talking to those in your family about, do they have a will in place so that their wishes are known on paper, and so you don't have to like defend them before a perfect stranger, a judge in the court, taking months, maybe even years to get their estate settled. This is something super duper important. Again, I hope you all found value. If you did, before you leave, hit that thumbs up button. It's free. Subscribe to the channel and share this with someone. All right, I appreciate you. Bye.